Hello, everyone. Good afternoon. Thank you for joining us in this panel on the intersection between three landmark European pieces of legislation, GDPR, AI Act, and Digital Services Act, known as the DSA. We hope that you find it interesting because, as you all know, technology is becoming increasingly a part of our everyday lives and is transforming literally every aspect of the human activity. And because of that, European Union has in the recent years shifted its priorities in realizing its vision for a digital single market that on the one hand strives to respect human rights and on the other hand aims to promote competitiveness of the European economy and innovation. It's a tough balancing act, but we will see how it goes. And as part of this wider strategy, this wider digital strategy, it has various components: data, AI, cybersecurity, platforms, and intermediaries. And so in this context, since 2018, we have enforced GDPR, which concerns the processing of personal data. On the other hand, since 2022, we have enforced the Digital Services Act that applies to online platforms and intermediaries such as social networks, online marketplaces, and apps, and addresses on topics like illegal content, disinformation, and transparent advertising. And since August, we have enforced AI Act, which imposes obligations on AI systems operators like providers, importers, distributors, and deployers in order so that in the European Union we develop, use, and place on the market AI systems in a trustworthy and ethical manner. And one may ask themselves, how do this piece of legislation interact between them? For example, in AI Act, high-risk AI systems must be designed according to the principles of accuracy and transparency, which is something that applies also to the processing of personal data according to the GDPR. On the other hand, we have deepfakes, which are regulated both by the AI Act and the DSA. But this intersection leads to both overlaps and conflicts and makes compliance for businesses much harder today. And this is the riddle we are called to solve today. So without further ado, I would like first to address Mr. Vasilis Karkatounis, who is the legal policy advisor of the Hellenic Ministry of Digital Governance. So Mr. Karkatounis, we have these three aforementioned pieces of legislation: AI Act, DSA, and GDPR. But there are also other pieces of legislation. For example, as we know, on September 5th, 2024, the Council of Europe opened for signature the Framework Convention on AI. Could you provide us an overview of what the convention entails? Is it legally binding, and what is its relationship with the Greek law?
Thank you. It's a great honor to be here with you today. Thanks for the invitation. Actually, I had the privilege to participate in the negotiations of the Convention on AI with the lead, of course, of an excellent colleague from the Ministry of Foreign Affairs, Ms. Kastrada. The Framework Convention is operating at a high level. This is very important to note, and it's complementary to already existing framework. The goal is to fill gaps that have formed as a result of rapid technological advancements and in the sphere of human rights law and, of course, the protection of democracy. It is very important to note that the Convention applies both to private and public sectors, and it has only limited exceptions regarding national security, national defense, and, of course, research and development. The conventions require activities within the life cycle of AI systems to comply with certain requirements and central fundamental principles like human dignity, individual autonomy, equality, non-discrimination, privacy, transparency, and safe innovation. And it provides certain remedies, procedural rights, and safeguards, such as the obligation to document information regarding the use of AI system, making them available to the users, and of course the possibility to lodge a complaint to competent authorities if necessary. It might sound a lot, but it is very, very similar to the AI Act. And it should be noted that the EU Commission was not only present, but it had the lead during the negotiations, representing all 27 member states. And it is very important to note because the key goal of the EU Commission and the member states was to have two texts that are similar and do not create separate frameworks that would create separate obligations or more obligations for member states. One of the most important aspects, if not the most important in my opinion, of the convention is the risk and impact management system, because it does not only impose a general obligation for a risk and impact management system to apply, but it also describes a methodology and an operationally feasible model facilitating this methodology. Of course, both of these tools are not legally binding, but the group leading the CAI is already working on this standalone instrument. It's called HUDERIA. It stands for Human Rights, Democracy, and the Rule of Law Risk and Impact Assessment. It's a very long name. It's an awful idea to leave lawyers to name things. So it's a very important framework, not only because it detailedly describes it provides guidance regarding risk and impact assessment, but it is very important because the European Union will take this methodology into consideration when forming its own impact assessment. As you all know, the AI Act provides for fundamental right impact assessments, so there will be an effort to bring these two in line. Another, and that's the last point I would like to make, a very important aspect of the convention is because it's working under the Council of Europe and not the European Union. This is a very important distinction for non-lawyers. It means that it enhances international cooperation. So during the discussion, many countries outside the EU, which are very important players in the AI arena, like the United States, Canada, Japan, they have participated in the negotiations, and actually at this point the convention is signed by around 10 or 11 countries, and among them it is the United Kingdom, Israel, the United States, and the EU as one, and this is very important that not each member state has signed the convention. It is not yet legally binding, to respond to your question. It will enter into force once 5 states, including 3 members of the Council of Europe, have ratified it. It is not yet done. But it's very important that the EU has signed the convention, so it will be the one to ratify it. There will be no need for ratification at the national level from its member state. And to sum it up, the convention has many didactic and very useful aspects, but at the time being, I would definitely focus on the AI Act for the implications that will bring to the national order.
Thank you very much for the very comprehensive summary that you provided us of the provisions of the Framework Convention. And it is indeed crucial to underline that this convention comes to supplement the provisions of the AI Act, especially regarding the fundamental rights impact assessment, which also highlights the intersection between the other pieces of legislation. For example, we see an overlap of the FRIA with the DP under the GDPR. So thank you very much for that. Now I would like to turn to Mrs. Christina Grigoriadou, who is an economist and an attorney at law at the Moussas and Partners law firm. Mrs. Grigoriadou, as you know, the AI Act has adopted the risk-based approach. Does this approach also extend to GenAI models as well?
Hello, and thank you for being here today. Thank you for this question. So, my name is Christina Grigoriadou, and I represent Moussas and Partners law firm. As a start, I'd definitely like to say that AI is taking the world by storm, and in the world of generative AI, creativity knows no bounds, and businesses have endless possibilities. So whether you're a corporate executive, a tech enthusiast, or a legal professional, understanding the AI Act is crucial for navigating the evolving landscape. In the Parliament proposal, the European Parliament defines generative AI as a type of foundation model. Foundation models are defined as AI system models trained on large and diverse data sets designed for generality of output that can be used for many different tasks. Generative AI systems are a specific subset of foundation models specifically intended to generate with varying levels of autonomy content such as complex text, images, audio, or video. So let's see the EU approach to generative AI. The AI Act extensively regulates general-purpose AI, such as GenAI. The Act differentiates the general-purpose AI models based on their risk levels, systemic or non-systemic. A general-purpose AI model, such as ChatGPT and many more, is deemed a systemic risk if it demonstrates high capabilities. Additionally, the European Commission may designate a special-purpose AI model as having systemic risk based on various factors, such as the model's complexity of parameters, its input-output modalities, or its reach among business and consumers. For the general-purpose AI providers, there are specific obligations. So the most onerous requirements under the AI Act attached to general-purpose AI. The requirements for most general-purpose AI models, which include foundation models and generative AI models, are chiefly focused on transparency. All providers are mandated to disclose when users, i.e. natural persons, are interacting with an AI system unless it's obvious, such as generative AI chatbot, and to label all generated AI outputs in a machine data-readable format. General-purpose AI providers also need to have publicly available and detailed summary of the content that was used to train the model. Just a quick distinction between model and system. The AI model is a central component of artificial intelligence. It's a mathematical or statistical representation of a specific problem developed from data. The system is a much more broader and complex application that integrates one or more AI models to accomplish a specific task. So in the Parliament proposal, there's a three-pillar approach. Generative AI systems are subject to three overlapping sets of obligations. The first is general obligations for AI systems, depending on risk category. The second is obligations for foundation models, and the third is obligations for generative AI. For the specific obligations for generative AI, in particular, providers will have to train, design, and develop the generative AI system in such a way that there are state-of-the-art safeguards against the generation of content in breach of EU law. Document and provide a publicly available detailed summary and the use of copyrighted training data. Comply with stronger transparency obligations. The former two obligations aim to protect against the infringement of intellectual property rights, and the latter obligation aims to avoid, through transparency, the use of a generative AI system to create manipulative content. Where a generative AI system has been used to create deepfakes, the users that created such content must disclose that the content is AI-generated or manipulated, and where possible, indicate the name of the legal or the natural person that generated or manipulated the content. So I don't want to go into detail about the foundation models or the third general obligations applicable to all AI systems, just to add that the recitals of the AI Act clarify that the development of a generative AI system or foundation model as such does not lead to high-risk classification. Rather, for specific generative AI system, one must assess what the risk classification of such AI system is and comply with the corresponding obligations. Thank you.
Thank you very much. It is indeed crucial to underline that GPAI was not a thing when the proposal by the Commission was first launched in 2021, so that shows how quickly technology evolves. And now I would like to turn to Mr. Iakovos Armas, who is a lawyer specializing in DSA and competition matters. And Mr. Armas, so in your view, what are the main areas of overlap and conflict between DSA and the AI Act?
So thanks a lot for the invitation and this opportunity. I think that everyone can argue that the AI Act and AI regulation in general has been, has been the focus of various legal conferences and discussions over the last couple of years. And I think that we, as a community, we have not been as fair, let's say, to the DSA, even though it can be quite as important as the AI Act and even more important in certain respects. And I think that the core obligation, so for those of you that don't know, the DSA lays down various obligations for online platforms. I think our moderator already mentioned a few. And but for certain big platforms like Facebook, TikTok, X, YouTube, there's those that in the European Union have more than 45 million users as an average monthly on an average monthly basis. They have some extra obligations, and the most important of these obligations is risk assessment and risk mitigation, systemic risk assessment and mitigation. So they have to perform annually and also on an ad hoc basis every time they introduce a new feature, risk assessments, and make sure that the systemic risks that they identify are properly mitigated. And this is something that we see in the AI Act as well as a concept and as an obligation of providers. For example, you mentioned deepfakes, and this is in the DSA. There's no law that says that deepfakes are prohibited, or you just have to. The platforms just need to the extent that deepfakes present a systemic risk, they have to assess how important it is and mitigate it. And I think that instead of you asked me about overlaps. There are various overlaps, technical overlaps that we can point to in terms of transparency and reporting and in various sorts of areas. But I think that an important question to raise here is who is actually looking after all these things. And when it comes to the DSA and these big platforms that I mentioned before, it's the European Commission that has exclusive competence. That means that the European Commission, which is already investigating many of these platforms, will eventually render some decisions. And since we started advising all these platforms ahead of the DSA, and we dealt with several questions, and one of the questions that we kept having from our clients was what is a diligent risk assessment, or what is an effective mitigation measure? Is there case law on that? Because you are lawyers, you tell us what to do. There isn't sufficient case law. And what I'm getting at basically is that the Commission will issue decisions. Chances are that this will be litigated. They will end up in the EU courts. In Luxembourg, and the DSA will get there first. And however the court interprets these terms, these issues, they will certainly, trickle down to how the AI Act is enforced. So I think I'll stop here, and yeah.
Thank you very much. What we would like to retain in our minds is the word risk that exists both in AI Act and the DSA, transparency, reporting, and that we as lawyers are called to solve many novel issues and be really creative. So now I would like to ask Mr. Evangelos Zargadoulas, who is a researcher at the VUB University and a police officer in Brussels. Mr. Zargadoulas, as you know, the AI Act contains certain prohibitions on AI systems. To what extent do these prohibitions impact law enforcement?
First of all, thank you for the invitation. I'm really glad for my participation in this panel and the opportunity to present the impact of artificial intelligence on law enforcement. Apparently, the Artificial Intelligence Act, as an horizontal legal instrument, regulates also the law enforcement sector. However, this approach by the Commission was not self-evident and was questioned by some member states in the Council. In particular, a few delegations from the Justice and Home Affairs community generated the idea, after exactly the proposal's announcement, to distinct the law enforcement from the private and public sectors, bearing in mind the paradigm of General Data Protection Regulation and the Law Enforcement Directive in the context of personal data protection. But this initiative was not moved forward due to its limited support. Despite that, the attempt continued through the legal basis of the proposal. During the discussions, the competent working party of the Council, the legal service of the Council was requested and issued an opinion on the legal basis of the proposal and the appropriateness of the Article 87 of the treaties on police cooperation. With this regard, the Article on Police Cooperation is verified that it's not the proper legal basis, with the reasoning that the proposal on artificial intelligence does not directly pursue public security objectives, it does not concern the police cooperation stricto sensu. In terms of the prohibitions and analyzing Article 5, describing all the bans of this proposal, I will navigate two practices and the implications in law enforcement. To begin with, the individual risk assessment, including profiling in predicting criminality, is banned except when it is related with an actual criminal activity, even if an individual is a suspect, and after, of course, a human assessment. What this means in practice, that this prohibition applies when the individual risk assessment is based solely on a personal behavior or the personal trait or characteristics without any link with the criminal activity. So I do not see a real impact of this prohibition on law enforcement. When it comes to the real-time remote biometric identification in public spaces for law enforcement purposes, one of the controversial topics of the Artificial Intelligence Act, the regulation foresees narrow substantial, procedural, and reporting requirements. Substantially, this derogation should pursue three goals: the search of victims of abduction, human trafficking, sexual exploitation, and missing persons, the prevention of a threat against life and a terrorist attack, and the detection of a suspect or a fugitive of severe crimes. As regards the procedure, authorization by a judicial or independent administrative authority is essential, defining the temporal, geographical, and personal scope in compliance with the principles of necessity and proportionality. Regarding the reporting requirements, the national competent authorities must send annual reports to the Commission about the use of this technology, and then the Commission to publish a yearly document. To complete my response, to inform that the European Commission will produce guidelines on the prohibitions, and their processing is underway. We expect their publishment at the beginning of next year, in January, and definitely before the implementation in February. Thank you.
Thank you very much. It is indeed real-time remote identification is a hot topic, as shown by the cameras that were used in Paris for the Olympic Games, and the many reactions that were against that. So it is a tough balancing act. So now I would like to turn to Ms. Hara Stefano, who is a senior project manager at Majoli SPA. So, in order to showcase a more practical side of things. So, Mrs. Stefan, as you know, data, both personal and non-personal, power AI applications, and privacy by design is an emerging trend in GenAI models. Could you provide us with a practical example of the implementation of the privacy by design according to your experience?
Hello, thank you for the invitation, and it's an honor for me to be here. Gruppo Maggioli is a leader in digital transformation and public services with headquarters in Italy and a presence around the world, including Greece. So I will talk more from a technological perspective and how AI solutions actually comply with these laws and regulations that we've heard. Privacy by design is data security and protection through technology design. So it's not just evaluating these at specific intervals, as Mr. Sarma said, but rather integrating into every stage of the development and starting from the beginning proactively. So one of our recent research initiatives that embodies this principle is the AI for Gov project, which is funded under the Horizon Europe program of the European Commission. It started in January 2023, and AI for Gov stands for Trusted AI for Transparent Public Governance, Fostering Democratic Values. It is a collaborative activity among universities, research organizations, SMEs, large companies, and of course public bodies and institutions, such as the Ministry of Tourism and the municipality of Voulavari Vouliagmeni. It harnesses AI and big data for public good, also ensuring privacy of people's rights. One of the frameworks that AI Gov has developed is the data governance framework that sets standards of how to manage data throughout the project so as to remain secure. Another one is the holistic regulatory framework that regulates the usage of AI in the public sector, ensuring trusted and reliable and bias and discrimination-free usage of AI. Privacy by design means that we have safeguards throughout the process of the project and not just applied at the end as a remedy. AI for Gov can be, we can tell that it is a case study of how privacy by design is implemented in order to develop solutions for a future of AI in the public governance, which is transparent, trustworthy, and respecting human rights.
Thank you very much. Due to time constraints, I would like to ask all of you to answer my questions in about 1 minute, if it's possible. Mr. Kargajounis, so we have now the AI Act in force, and there is one question in everyone's minds. Which is going to be the public authority enforcing AI Act here in Greece?
Yeah, that's the million-dollar question, I guess. Well, first of all, I will try to be brief, and this timer, as if our life was not stressful enough, we have a timer here making it worse. So, well, technically, AI Act is not in force yet. I mean, luckily for us, but I think that our stress level would also go to next level. But at the time being, what happens in the Ministry of Digital Governance is that we have set up a working group with 3 distinctive tasks. One is to decode the AI Act and to see what our responsibilities are at a national level. One very important, for example, is the one that will provide for the national framework regarding the prohibition of real-time biometric identification that Mr. Tatkardoula said. And by the way, I would like to say that in general, dealing with the AI Act is a very onerous task. When I used to be outside the ministry, I would be more judgmental, but at the time being, I am really appreciative of people representing representing Greece, like Mr. Zakadoulas, and I have to mention, because they're doing an excellent job, both in transferring knowledge from the European Union, but also stating our opinions in the Union. The second task, it's also very difficult, is to map the Greek law and see whether there are existing provisions regarding AI and how these should be modified. And the last but not least is to set up a governance scheme for Greece. At this time, there is no final decision. We are looking and examining into examples of other countries, best practices. Some of these countries, personally, I really like the Dutch example, the example of the Netherlands. They have published an advice which is very detailed about how they're setting up their mechanism. I think that this model suits Greek needs better because it's not purely concentrational, it is actually very horizontal. We should leave competencies within authorities that already have the know-how of doing things. And I think that for many, many reasons, I wouldn't see a new authority being set up rather than current authorities being evolved. So we already announced the authorities regarding the protection of fundamental rights, which is, we are one of the few countries that did that in the EU. So I think that this is an important part of the whole governance framework that we want to set up in order to be able to cope with the requirements of the AI Act.
Thank you very much. It is very important to have insight from the Ministry of Digital Governance, and you're not appreciative of the hard work on the backstage until you're involved in it. Now, Mr. Sarmas, recently the European Commission launched a formal investigation against many social media platforms like X, formerly known as Twitter, for violations of the DSA. Since we have AI being directly involved in the content moderation, the development of interface, how do these developments affect users? Can DSA protect us?
So I think that, again, we have to understand what's the context of these investigations and what's the goal. I'll try to be brief. So 2 years ago, this regime did not exist. And now that it exists, the Commission has launched various investigations against X that you mentioned, Instagram, Facebook, TikTok, AliExpress. I don't want to miss anyone, but and these are non-compliance investigations. What this means is that the Commission will either give a stamp of approval and say that, for example, everything works well, no problem, no infringement. It will say there's an infringement and here's a fine, or there will be some sort of commitment and the investigation will close with some adjustments to the service. And but what's interesting here, because personally I have a competition law background, and before I started working intensely with the DSA, I was working in all these investigations, and in antitrust, if there's an infringement, there's a fine, then the infringement has already stopped. But with the DSA, it doesn't work like that. The Commission, if it issues a non-compliance decision, it has to provide actually some some measures that the platform will need to implement in order to address its concerns. So it won't just be, yeah, you did wrong, pay a fine, and life goes on. They really need to say what they can do in that context. So I think that this is something that has not been tested. I think we will see some examples in the next months, maybe 1 year. But eventually, I think that since all these services are regulated, basically like banks, and now we have, banks that, like these platforms, they need to address systemic risks, and they're regulated. Eventually, the goal of the Commission is to reach that stage that they're basically, all the systemic issues have been looked at and have been addressed. And I don't know when this is going to happen and what it will take, but I think that, yeah, it will, at some point, the Commission will make sure we will reach that stage.
Thank you very much. Indeed, we have many things to wait from the European Commission in the next months. So now, returning again to law enforcement, Mr. Zarkadoulas, as you know, bias is a very well-documented issue in many AI systems. Do you see any risks by the use of GenAI by the law enforcement? And has there been any such incidents either in Greece or abroad?
We should admit that bias is an undeniable aspect of large data sets, and the law enforcement does not elude from this consideration. Historical data potentially contain stereotypes and systemic inequalities, and they're used to train algorithms perpetuate biases. Discriminatory practices from police authorities gonna leverage artificial intelligence have not been recorded across Europe so far. On the contrary, and looking globally, false facial recognition matches and problematic predictive policing systems have been observed. At this point, I would like to highlight that the police forces in the United Kingdom have used the real-time remote biometric identification public safety technology for almost 10 years without any wrongful arrest. So the next question is how to eradicate bias. I will mention and I will suggest some measures. For example, the training of personnel, compliance with the Artificial Intelligence Act, the involvement of legal experts on data protection and fundamental rights, and the oversight of national competent authorities for mitigating bias and discrimination against marginalized and vulnerable groups and minorities. Thank you.
Thank you very much indeed. Education is very important. It's the cornerstone, I would say. Ms. Grigoriadou, now turning to you. You're often advising clients in the automotive industry. To what extent are companies in this sector using AI in manufacturing or embedding AI in their products, and do you see any risks there?
Thank you. Our firm recently contributed to the Smart Green Island with the aim of transforming the island of Astipala in a pioneering mobility system. So I will respond to this question as we've been working with automotive clients for a few years. So definitely the technology of AI has been reshaping numerous sectors, including the automotive industry. And leading automotive manufacturers are integrating AI into their operations, leveraging its potential gain, to gain a competitive edge, and offering consumers personalized experiences. So the role of AI in the automotive sector extends beyond manufacturing, revolutionizing automotive retail as well. Volkswagen, for example, established an AI company. It's the AI Lab. This new infotainment and navigation applications, high-performance speech recognition, extended vehicle functions, and the deep integration of digital ecosystems in the car will bring considerable benefits to customers, enhancing the experience of the product. This AI lab is actually aiming to rapidly develop digital prototypes and transfer them to the group brands for implementation. ChatGPT is also available now in many Volkswagen models, and the customers can now have search results by reading out to the application, and the car interacts using natural language. Skoda is also testing autonomous drones for inventory management at its facility, and these drones, equipped with sophisticated recognition technology, survey the storage area 3 times daily to track and count empty containers, automating and improving accuracy in the inventory management. So the impact in the automotive industry is big, and we can see that there is AI in the manufacturing process, enhancing experiences with AI, improved dealership services, and revolutionizing dealership marketing. So I'll just try to be very quick. The AI is transforming the future of the automotive industry, and we see that there is enhancement of safety. We see that there are in the automotive operations, we see AI in the manufacturing process, and we see that there is a personalized vehicle experience. And as a last point, very quickly, 8 use cases for AI in the automotive industry, driver assistance systems that they aim to make much safer the experience, AI-driven marketing for dealerships, autonomous vehicles we all know, driver monitoring, supply chain management, AI in manufacturing, as I said earlier, personal assistant and predictive maintenance, and passenger experience. So we see that the AI reshapes this industry as well, as long as with other industries, and there are many different options for the manufacturers. Thanks.
Thank you very much. Indeed, we see many examples in the automotive industry, and that is very interesting. Now, last but not least, Ms. Stefanou, there is a project that is relevant to our panel called Themis 5.0. Could you tell us a few words about that?
Of course, Themis 5.0 is another project funded by the Horizon Europe program. It has to do with assessing and optimizing AI systems in terms of trustworthiness. We do that not only by considering the technological aspects, but considering that AI is used within a socio-technical environment and is operated by humans. So apart from algorithms and software, we talk about trust, responsibility, and ethics. So we need to deliver systems that are not only efficient, but also transparent and trustworthy. Themis develops an entire ecosystem to create AI that is trustworthy by design. And by trustworthy, we mean putting the human in the center, recognizing that human trust in AI is affected by human factors such as preferences, behaviors, and values. So we deploy several frameworks on ethics, like ethics guidelines for trustworthy AI, an ethical compass that's a framework guiding decision-making in AI development, utilizing virtue ethics, deontological ethics, and utilitarian ethics, as well as the Altai framework, assessment list for trustworthy AI, in order to create solutions that are not only trustworthy, but they can be trusted by humans.
Thank you very much. And I would like your answer in one sentence. What is the biggest challenge associated with GenAI from a legal, ethical, or technological perspective? One word, if possible. Mr. Sarmas?
I don't know, you got me. I mean, from the DSA perspective, I think it's what I said earlier in my first answer, that it's really how to define what is really an effective mitigation measure. How do you identify an effective versus, how do you distinguish an effective from an ineffective mitigation measure against, deep fakes, like you said before?
Thank you very much. This is very important to note. Mr. Grigoriadou, what do you have to say?
Well, I can't say that there is one primary risk associated with GenAI. Definitely there are legal risks, ethical and technological, IP infringement, for example, misinformation, deepfakes, as well as hallucination. So we definitely need to see how these can be mitigated, but definitely we're not sure if regulation is the only way. So yeah, there's no, not one answer, I think. It's a combination of things, definitely.
It is indeed hard, and it is a balancing act to find between innovation and competitiveness and human rights. We also want the perspective of the Ministry of the Digital Governance.
It's personal opinion, it's not of the ministry. So if you need one word, I would say autonomy, because I think that we often overlook the fact that we are humans, so we're full of cognitive biases. we're not unbiased at all, and we create systems that, of course, they will not be unbiased. We're lazy. Some of our greatest achievements as humanity have been done because we're lazy, and we wanted an easy way to do things. So combine this with the increasing load of work, we have two main arguments. One is the awful human argument, which says that humans are making awful decisions, so machines should do them instead. And the other one is the better together argument, saying that people and machines will work effectively. I'm not that optimistic. If I may refer you to an article by Professor Solov, which is excellent and articulates these arguments very thoroughly. But I would say that my main concern is that people may end up as being vessels of liability instead of autonomous beings taking decisions for themselves.
Thank you very much for pointing out autonomy, because we sometimes forget that the human-centric approach is also an element of the AI Act. Mr. Zarkadoulias, what do you have to say on the topic?
From the police perspective, the paramount peril is organized crime networks and terrorist groups setting up their own highly sophisticated artificial intelligence tools. For the time being, they use commercial tools, and it is vital to consider that criminals and terrorists do not meet any legal constraints. Thank you.
Thank you very much. And now, Ms. Stefano, what do you have to point out?
I would like to say that one of the risks for GenAI is its adoption, and it might be hindered if we not consider human while we develop AI solutions, because if we don't understand how people interact with the system and how trust is built, then we may have systems that provide solutions that are not accepted by their operators because they are not either transparent or because they are not aligned with their ethical expectations.
Thank you very much. So we hold human on the center, autonomy, and legal clarity, and adoption by businesses, because without AI, our future as Europe will be far behind the US, China, and it's not something that none of us want. Thank you very much. We hope that you have enjoyed our session, and we're at your disposal for any further questions that you might have. Thank you.